Hi, everyone. Welcome to Norton Rose Fulbright's Texas Business Court Insider, where we're tracking developments in the Texas Business Court and beyond. Don't forget to hit like and subscribe so you get notified when we post a new video analysis. I'm Rafe Schaefer.
And I'm Andrew Price, and today we're going to be looking at House Bill 40, which passed at the very end of the legislative session and expands the Texas Business Court in a bunch of ways that we'll talk about. We're recording this episode on Friday, June 20th, and House Bill 40 was enrolled on June 2nd, and as of the time of this recording, Governor Abbott has still not yet signed the bill, but if it's not vetoed this weekend, it will become law on June 22nd. And maybe equally important, because it was passed by a 2/3 or better vote of the Texas legislature, House Bill 40 will become law immediately, essentially on Monday. So this is a timely report, Rafe.
Yes, it is. And we're going to focus on four key aspects of the business court's expansion under HB 40. We're going to talk about the reduced amount in controversy requirement. We're going to talk about expanded jurisdiction over subject matters like arbitration, trade secrets, and intellectual property. We're going to talk about some modified jurisdictional procedures and rules that are coming. And we're going to talk about the court's expanded geographical boundaries. So Andrew, let's dive right into the amount in controversy requirement and how that has changed.
Sure, Rafe. Listen, this has gotten a lot of the headlines, and it's really simple. The amount in controversy requirement for these complex commercial disputes was at $10 million. And it's being lowered to $5 million, excluding interest, attorney's fees, and cost. And so it's going to match what was previously the amount in controversy requirement for corporate governance disputes over privately held entities. And not surprisingly, this is going to mean more cases will be removable, more cases will be immediately fileable, and essentially just more cases will find their way to the Texas Business Court.
In a similar expansion, HB 40 is also going to expand the statute's definition of qualified transaction. It allows, instead of requiring a single transaction of $10 million or more, it allows the qualified transaction to be a series of related transactions. And again, this will generally allow more commercial disputes to end up in the Texas Business Court by allowing the court to consider, a range of related transactions to determine whether the qualified transaction requirement is met. So again, just a broadening and expansion of the court's subject matter jurisdiction for those complex commercial disputes. Let's turn to our second topic, Andrew, which is the expansion of the types of cases the business court can adjudicate now under HB 40.
Well, right, Rafe. So the legislature chose to expand the types of cases to include matters related to arbitration, intellectual property, and trade secrets. And starting with arbitration, the business court now has jurisdiction over actions to enforce arbitration agreements, appoint arbitrators, review arbitral awards, as long as the underlying arbitration meets the other jurisdictional requirements of the business court.
And there are a number of procedural modifications that come along with that, Andrew. HB 40 amends the Texas Arbitration Act, which is Chapter 171 of the Civil Practice and Remedies Code, to allow for venue in the business court for those mid and post arbitration applications that you mentioned. It also amends Chapter 51 of the CPRC to allow for appeals from the business court in the same ways you can appeal an arbitration-related decision from the district court. It also amends Chapter 51 to authorize interlocutory appeals from the business court for any order that's appealable under the FAA.
Well, right, Rafe, and as many of our watchers know, Texas not only has a codification of rules related to domestic arbitration, but there's also Chapter 172, which deals with international arbitrations and international arbitration procedures. that can occur in Texas courts in aid of those arbitrations. And the business court has now got jurisdiction over those matters as well. So a lot of the things that you just touched on related to expanding business court jurisdiction to domestic arbitration are now going to be applicable to international arbitration, again, as long as that underlying international arbitration otherwise meets the business court's requirements.
HB 40 also, as you mentioned, Andrew, grants the business court subject matter jurisdiction over trade secret disputes and intellectual property disputes. This again allows the business court to hear cases that otherwise may not arise out of a qualified transaction, but might arise under the Trade Secrets Act, Texas's Uniform Trade Secrets Act, and otherwise have $5 million or more in controversy. Andrew, kind of looking at these jurisdictional expansions, what's the real takeaway for the listener today?
Well, I mean, I think it's that the business court is viewed as being successful. It's viewed as being efficient and accomplishing its goals of steering complex matters that perhaps the regular district courts are ill-equipped to handle given their large caseloads. And so the legislature is going in and is kind of expanding the types of matters, because there's a lot of other types of complex commercial matters that otherwise were not able to go into business court, and the legislature is saying let's funnel those matters as well to these judges for efficient and quick handling.
Right, and I think it continues to maintain those initial distinctions that were made in the establishment of the business court between commercial disputes and complex commercial cases and personal injury disputes or other types of cases that haven't been intended to be brought in business court, and allowing arbitration-related applications, trade secret disputes, intellectual property disputes, doesn't really blur that line. It focuses on those complex commercial type cases that the business court appears primed to continue to handle. So that's really the subject matter, Andrew. Let's turn and focus a little bit on the procedure. How does HB 40 affect, practice and procedure in the business court?
Well, for folks that have been watching our videos or looking at our content on the Hub, you'll know that many of the opinions out of the gate from the business court dealt with these jurisdictional issues. Things like removability of matters, amount in controversy, whether or not something is a qualified transaction. And I think recognizing that the fact that you might have a bunch of litigation or disputes at the outset of a case over whether or not the business court actually should be hearing the case, on some level conflicts with the underlying goal of let's move these cases quickly and efficiently towards a merits resolution. And so recognizing that, the business court has authorized, or the Supreme Court is now going to be authorized under the HB 40 to promulgate rules to essentially get these jurisdictional issues resolved once and for all at the outset of the case.
Right, and the legislature has specifically instructed the Supreme Court to consider establishing a limited period of time at the front end of a case where a issue or a jurisdictional right has to be asserted, or it will be considered either agreed upon or waived, which, as we've talked about in prior videos, is very interesting because the business court is really one of the only jurisdictions in the world where parties can agree to subject matter jurisdiction. HB 40 might even expand the abilities of parties to agree to that jurisdiction. And it's likely a response to the fact that, again, so many of these initial business court opinions have dealt with subject matter jurisdiction issues, Andrew. And so for the business court practitioner, what's the so what of the Supreme Court's rule promulgation, Andrew?
I mean, I think the so what is, consistent with the goal here. Your jurisdictional issues are going to need to be resolved at the outset. They are going to be resolved one way or the other, and that's going to be essentially the end of it. Things that none of us as practitioners really have dealt with, things like the ability to waive your right to challenge subject matter jurisdiction, are now on the table in business court, agreeing to jurisdiction in the business court, those sorts of things that are really not typical, as you touched on, in any other jurisdiction. Those are things that are in play. And I think it's designed to avoid situations where we spend a lot of time getting to the merits resolution of a case, and then someone's going to pop up on appeal with a archaic subject matter jurisdiction gotcha and force the parties to redo the whole case. That's just not really in the cards, I don't think, the way the legislature and the Supreme Court's kind of follow-along rules are going to set this up.
I think that's right, Andrew. And to that point, the Supreme Court can even establish rules for the business court's jurisdictional rulings to be reviewed by another judge on the business court, a panel of judges, or the regional presiding judge or the administrative presiding judge of the business court. So effectively, the Supreme Court could say jurisdictional rulings of the business court are going to go to Judge Dorfman, the administrative presiding judge, for him to either affirm it or modify it.
And that's the end of it.
And that's the end of it. Or the Supreme Court may allow for rules that would require or prohibit interlocutory appeals, accelerated appeals, or any other procedures necessary for prompt, efficient, and final determination of business court jurisdiction. So again, Andrew, to your point, the legislature is keyed in on ensuring that these jurisdictional determinations are going to occur fast and they're going to be final.
Yeah, and so the rulemaking process that we're going to now go into is going to be super interesting for sure. Well, so let's talk to geography, some kind of really nuts and bolts, blocking and tackling here about the HB 40, because it makes some big moves regarding the physical location of the courts. It requires that chambers be established for all the judges. It adds some operating divisions subject to someone finding the money to fund these new divisions. And it expands the 11th division where you and I sit, the boundaries of that division.
That's right. And previously, the business court has been borrowing courtrooms in the various counties that it operates. But HB 40 will now require those counties to accommodate the business courts with chambers and courtrooms that are at least equivalent to those provided to district courts. So the business courts will now have home courtrooms in their largest counties.
And it also requires the judges to maintain these chambers in the county with the largest population within the division or an immediate adjacent county within the division's geography. There's some changes and exceptions that the Chief Justice can make to that, but generally they want these judges located in the population centers of these divisions.
And as you mentioned, Andrew, HB 40 establishes the 2nd, 5th, 6th, 7th, 9th, and 10th business court divisions. Those are the divisions that were not originally made operational. They are now established, although they aren't going to be staffed unless and until the legislature funds those divisions.
Right, and the indication is that the earliest that may happen would be 2026. It's going to cost, upwards of tens, we're in the tens of the millions range to get these other courts funded. So it's still a wait and see, but it'll be at least another, I would think, year and a half before these other divisions get off the ground.
And HB 40 expands the 11th Division's geographic boundaries. It effectively moves Montgomery County into the 11th Division. So if you have a case brought in Montgomery County, it didn't used to have an operating division of the business court. It's now part of the 11th Division with Judge Dorfman and Judge Adroge. And so if you've got a $5 million commercial dispute in the Woodlands as of Monday, June 23rd, 2025, you can think about bringing it to business court.
Right. Well, look, that kind of brings us to the end of our discussion of House Bill 40. We've previously talked on a prior episode about Senate Bill 29. I think any observer or listener to the show here can ascertain that the legislature was busy this go around, and they were busy in expanding the business court. They were busy in altering a lot of the rules around corporate governance, all designed to continue this push of Texas as a pro-business state, as a pro-business hub, and basically the ambition of Texas to begin to challenge some of these other states who have historically, held the mantle of, corporate law.
And everyone here at Norton Rose Fulbright's Texas Business Court Insider is continuing to follow these developments. Thanks for catching this week's episode, and we will see you next time.